This special meeting of the Judson Board of Trustees is hereby called to order at 5:30 p.m. I am pleased that you've taken time to join us this evening. In compliance with the State Government Code on open meetings, tonight's agenda has been appropriately posted, and we have established a quorum. I will call roll. We have our entire board present, and Dr. Fields.
Good evening.
So we will go straight into acknowledgement of citizens to be heard. And we have one citizen, Roger Roman, agenda item number 4. Mr. Roman, you'll have 3 minutes. Come right up.
Speak up here?
Yes,
Yes,
sir.
sir. Oh, sorry.
Yes, this evening I see you have a public grievance filed by Mr. Garza. I'm speaking to express my disappointment with this body. I'm a resident here for over 30 years. I have 6 children, 4 of which graduated from this school district. The other 2 graduated from Corpus Christi. I'm disappointed because this body is being used to target individuals for political reasons outside of this here. Mr. Garza is a council member over in the city of Kirby. I live in the city of Kirby, and it's disappointing when I see a political body being utilized to attack political candidates outside of what their scope is. And that's exactly what has happened. I know this. I was on city council in Kirby. One of your board members up here, when I was on council, posted a sign attacking me. That's the character of individuals up here. No, the JISD individuals did not vote for this individual. She was appointed by this board. That being the case, any problems coming down on this item here, and if there is legal ramifications, understand this. You all brought it upon yourself because, you don't vet people appropriately. The individuals up there should be voted for by the individuals of the school district. And I just find it troubling when this body, it's a powerful body, and it's got a very wide breadth and scope of reach. And when individuals are being attacked because of the wishes of an individual up here and people going along with it, I find it really, really troubling. Thank you for your time.
Thank you. We are waiting our legal counsel to get here, so I'm going to rearrange the agenda to get to our discussion and consideration of action items. Ms. Kyle should be here in about 15 minutes, so we have time to address these 2 items. And so number 7 on the agenda, discussion, consideration of action items. Letter A, discussion and possible action regarding approving the purchase of 1 yellow 14-passenger bus. Dr. Fields.
Yes, sir. In the 2022 bond, there were funds left over for transportation to purchase a bus. They were contacted and let known that there was a bus that was available now. Typically, you have to order them, and it takes a while for them to prepare the buses to get in. We do have enough money left over. It's $113,000. Well, you can see the price. And we're just asking the board to approve the purchase of that for transportation, which was in the 2022 bond.
Are there any questions? Ms. Ryan?
Is this the last one then under 2022? Right, because we've approved a bunch of these. Is this kind of close out the bus line for now?
Yes, ma'am.
Okay.
They've exhausted all the funds that
This is
we
the last
had,
one.
but yes, ma'am.
Okay, awesome. No, thank you for getting all that done.
All of the new buses have seatbelts, ma'am.
Thanks.
Just a clarifying question. So this is one, we're essentially getting a bonus bus, is that, so to, like it was, we already had gotten what we budgeted for, this is using extra funds, or this is one of the buses that we had planned on buying?
We had a budgeted amount for buses. We purchased buses with what we had. We had money left over.
Okay.
This takes care of the money that was left over.
Got it. Okay, thank you.
Yes, ma'am.
No further discussion, then let me make the motion. I move that we approve the purchase of one yellow 14-passenger bus.
Second?
The motion's been made and seconded by Ms. Rodriguez. Let's go ahead and vote. Okay. Motion passes 7-0. Letter B, discussion and possible action regarding approval of an amendment to the current compensation plan for the 23-24 fiscal year. Dr. Fields.
Yes, sir. This is discussion and possible action for improvement for the amendments for two areas, additional, to upgrade our chief financial officer. The CFO position is one that we've tried to hire for in this position for quite some time. I can tell you that we even put in requests for hires at one point for an individual and was denied by that individual based on the salary that we presented to them. In addition, when we did the last survey with TASB, as well as Moss Adams, they were saying that in terms of market value, we didn't pay enough in this particular position. So for us to get a qualified individual in here to serve as our chief financial officer, we are asking that we move that pay grade to a new pay grade of 512, which will allow us to interview and get someone in for that particular position. And we feel that we will be competitive for not only the local area, but for across the state as well. And this is the recommendation of our Deputy Superintendent of Business and Operations.
Any questions?
The other one on here, I guess I should speak to that as well. I apologize. In posting of our summer school hours, it was for last year's hours. We typically pay $55 an hour for those positions. Because the hours have changed, we're still paying $55 an hour, but we're basing it on the number of hours that they will be in those positions for the summer. When we originally posted it, a person could have assumed that they were going to get paid last year's payment. We called everyone who was selected or interviewed and selected for a principal, assistant principal position, and all of them agreed that they wanted to continue to come and work for summer school based on the salary. And we spoke with them today, correct?
Yes, sir.
Okay. And this is the recommendation of our Dr. Top and Dr. Saunders, based on summer school hours.
All right, Ms. Eaton, and then Ms. Stanford. Go ahead, Ms. Eaton.
So did the number of days change?
Yes,
or-
ma'am. I can let Dr. Saunders speak to that.
So still the same rate of pay, but based on the number of days that it's been decreased, that would decrease the overall rate. And we communicated that with them today.
How many days?
From 13 to 9, I think, is one example. It depends on the level. Elementary is different than middle school is different than high school. We also shared the salary breakdown. So 5 days of instruction, 1 day of PD, 5 planning days, 8 hours each one of those days, times $55 gets the overall rate.
And Ms. Davis can help you with that.
So just for example, last year, the principal pay was 22 days at 8 hours at $55 an hour. The rate has always been $55 an hour for administrators. And then this year, that has been reduced to a total of 13 days for principals. So that just reduces Rate is exactly the same, but because the number of days are reduced, the pay would be reduced.
Okay, I'm with you.
Ms. Stanford?
I just had a question on the salary for the chief financial officer. The range is 153 to 192. Do we have a target salary?
I can tell you that we do have a target salary. I hate to say that over an open mic in case people interview for it, but I can tell you it would be on the lower end of that, higher than the minimum, but, on the lower end, not the higher. In addition, one of the things that I can tell the board is that it's not lost on the cabinet and the administration that we have to be fiscally responsible. And one of the areas that was approved was the assistant superintendent position as we went into next year. I would ask that, I've already talked to the cabinet, we can absorb those responsibilities and then attribute the funds that we were going to put in that position into the increase of this position, because we all understand the need to get this position accomplished.
Could you clarify that when you say absorb?
The responsibilities that we were going to give to the assistant superintendent for next year, we will collectively take on those responsibilities, not hire in that position.
Okay.
Use the funds that have been approved for that position for this increase in this position. And that would be less than half of what we had approved for next year's assistant superintendent position.
Okay. Thank you.
Yes, ma'am.
Ms. Ryan?
I guess my challenge with summer school is how this was advertised, because when the email and the jobs were posted, it was not $55 an hour. It wasn't how it was advertised when you sent it out to the employees. It was sent out as the flat rate as approved by the board in the compensation plan. So, of course, if you're going to call those 14 people, most of whom are hoping to be associate principals and principals one day.
Yes, ma'am.
Absolutely none of them was going to tell you, no, they're not okay with it. Let's be real, because they want to move up in this district. So I'm not sure how genuine some of those responses really were, because, if I was trying to move up, I would not have done that. But we have already hired these people and we had published something that says what they were going to make. That's our error if we didn't look at this in February and March. When we're developing a summer school program and we're getting ready to launch what that's gonna look like, then those salaries should have been looked at earlier, before we advertised a job, definitely before we hired anyone for a job. And these people have been working this job for weeks. They're already hiring teachers and putting together their schedules. They're working on this stuff now. So to now kind of pull the rug off from underneath them because we didn't think of this stuff back when we should have thought of it, whether these salaries are right or not, what they should get paid, I feel like this is not the forum for discussing it, because we've already hired the people and we've already promised them this salary. So I don't think they should suffer for, if we made an error. And I really hope we look at how we do this in the future too, in the process, because maybe approving summer school pay when we approve the regular compensation plan in May and June, that might not be the right process, right? Because we don't know what that's gonna look like. Maybe we shouldn't even publish it for next year, because as we go through the summer school planning process and develop what that looks like, then put together a summer school compensation plan for whatever summer school plan you come up with. And then when you brief the board, hey, here's the summer school plan, here's the summer school compensation plan, we approve it all in one fell swoop, and then it gets advertised and put out to everybody. That just may be a better, procedural way, because a lot changes between when we may approve something in May and June of the next year. And that way we don't have documents hanging out there that people are working off of that they think the board approved when they took the job.
So I'm going to defer to Dr. Tagana, Dr. Saunders, and Ms. Davis, because all of them were involved in the advertising of these positions. I can tell you from the start, we understood that this should be calculated by an hourly rate based on the number of hours that they were in. I understand where you're coming from if a person looked into the compensation plan, so I'd ask them to speak on that.
Yes, ma'am. The compensation plan for summer school was introduced into the formal comp plan because it is something that we pay. And so I was advised that anything that we do pay get included into the compensation plan. But you are correct. When we published the compensation plan, it was for last year's summer school. So perhaps moving forward this year, we will put summer of 2024 so that everyone can be well advised that next year, we would have to update that for summer of 2025. That being said, I can provide the documentation because some of this is paid out of Title I and some of this is paid out of State Comp Ed, where we have to have that documentation for auditing purposes, what our hourly rate was. For ease of understanding for everyone else, we don't put how everything is calculated behind the scenes, but I can provide that documentation because it is something that we have to provide for auditing purposes. So I have documentation that shows that we had calculated that rate for administrators last year. And I can show you the comparisons of how we arrived, like I mentioned earlier, and I think I said 13 days, I want to correct, it's 16 days once you include the 9 days of instruction, 1 day of professional development, 3 days of registration, and 3 days of planning that we're compensating these administrators for. But we do have the backup. We'll be more than glad to take that feedback into consideration and post summer 2025 over that page for clarity purposes. I wouldn't necessarily put all of the backup to that, but I can most certainly explain that openly as we update the compensation for this coming year.
And I think if that had been in the advertisement, if it had said $55 an hour for 23 days or whatever it was, then that people would have done the math and figured out what summer school was. That's not the way we advertised it when they were hired for the positions.
We
So-
agree. So we called them back today, and they all agreed that they would be willing to do it for the $55 an hour. Yes, ma'am.
I was just going to say exactly what Ms. Davis did. You're absolutely right. We appreciate the feedback. Because we, even in January and February, were playing back and forth with how many days are we talking about, what's a good effective number to use. So if we had packaged that all at the same time, I just want to be really clear on the job description and when we're meeting with these administrators, we did not, it's not posted on there exactly what their pay is. Now, yes, they went and looked at the compensation plan, but we had a conversation, just a brief conversation about it would be disingenuous for us to decrease teacher pay because they're based on the number of days that they work. So it would be disingenuous for us to decrease teacher pay, but then leave administrators exactly where they were. So we did explain that to them, although we did not send an email or put it on the job description. We did talk to them about it, but you're absolutely right. We could have packaged it better in January and February, just to kind of sell the total package. Feedback received.
Ms. Canoyer?
Thank you. I don't know if it's possible or not, but could we look at possibly advertising and compensation plan $55 per hour for times number of days worked?
That wouldn't be
that's
much
much
better.
more generic.
Yes, ma'am.
They would see that, and, as we're talking then about summer school coming up, the number of days and so forth would be discussed, and they could calculate from there.
Yes,
And then we don't have to worry about having an exact number that changes from year to year based on the program.
Yes, ma'am. Yes, ma'am.
Yes, we will add the flat rate and the rate of per hour. And the reason that we add a flat rate is because oftentimes administrators will be asked to work more than a specific amount of hours. And so it might go beyond a specific number of hours. So I can add the 55, but also leave a flat rate not to exceed the flat rate that's posted.
Okay. No final questions. I wanted to just comment too that I know the administration's response was somewhat related to one of our teachers' unions asking questions about this, and I just appreciate you guys being responsive to that element. I mean, it's sort of how the process is supposed to work. So I commend the administration for that adjustment. So being no further questions, I move that we approve approval of amendment to the current compensation plan for the 23-24 fiscal year.
Second.
Motion made and seconded by Deborah Eaton. Please vote. Okay. Motion carries 6-1. Okay. We're, for the record, for our audience, we will only have one grievance today. We are postponing 6A, the grievance by Melissa Lozano. So we're going to move forward with our grievance with Mr. Garza. And he has requested that this session take place in open session. So we're going to start there. And there's some criteria that we'll read to you when we're ready for that here shortly.
So won't that 5 and 6 go together, right?
6A is not going to be heard today, so it'd just be 5A. And that's if, once we address this process. 3 and 4A, yeah, it's not 5A. It's, yeah, 3A and 4A, which is the open session request.
Yeah.
Okay. And I know that our counsel is here. Welcome, Ms. Kyle. So if you want to get started, we can.
Mr. Smith, I'd like to recommend that we have an attorney consultation and close
First. Okay. Then we'll go ahead and do that. Then pursuant to Texas Government Code 551071, attorney consultation regarding legal issues related to the public grievance. So the time is now 5:51, and we will go into closed session. The board will now reconvene in open session. The time is now 6:15. No final action, decision, or vote was taken while the board was in closed session. So we're now going to proceed with a grievance, and it is a grievance in open session. So we're here to consider and take possible action regarding the Level 3 public grievance filed by Mr. Christopher Garza. Mr. Garza, I'm going to read a script that is a little lengthy, so bear with me as I go through it, but it's part of the record. So, we are in open session to consider the Level 3 grievance appeal of Mr. Christopher Garza. Mr. Garza is appealing the Level 2 grievance decision made by the Assistant Superintendent, Dr. Lacey Gosh. This grievance is being heard in open session by the request of Mr. Garza. It is May 6, 2024 at 6:16 p.m. And we are here to hear the Level 3 grievance of Mr. Garza. We will now proceed to hear the grievance at Level 3. The following board members are present. Ms. Canoyer?
Suzanne Canoyer, present.
Ms. Rodriguez?
Jennifer Rodriguez, present.
Ms. Faulkner?
Stephanie Faulkner, present.
Ms. Ryan?
Monica Ryan, present.
Ms. Stanford?
Laura Stanford, present.
Ms. Eaton?
Deborah Eaton, present.
And I am Jose Macias, and I am present. Our school board's attorney, Paige Kyle, is also present to advise the board and the board president with respect to this proceeding. I will now ask each member of the board whether he is able to serve as an impartial member of the hearing body and to arrive at a decision based solely on the information and documentation presented at this grievance presentation. Any member not able to act in such a manner may say so and ask to be excused. Ms. Deborah Eaton, are you able to serve as an impartial member of this hearing body and arrive at a decision based solely upon the information and documentation presented at this grievance presentation?
Yes, I can.
Ms. Stanford, same question.
Yes, I can.
Ms. Faulkner, same question.
Yes, I can.
Ms. Canoyer, same question.
I'm able to.
Ms. Rodriguez
Yes, I can.
and Ms. Ryan.
Yes, I can.
And I, Jose A. Macias Jr., am also able to serve as an impartial member of this hearing body and arrive at a decision based solely upon information and documentation presented at this grievance presentation. A record is being made of this proceeding before the board in this Level 3 grievance appeal in order to provide the most accurate record possible. A recording of the proceeding is being made. Please avoid talking when others are speaking so that the record will reflect these proceedings accurately. As part of the record, this Level 3 grievance, the superintendent has supplied each board member with copies of the original grievance filed by Mr. Garza. All responses, any written documentation previously submitted by Mr. Garza, as well as the administration related to this grievance conference. The official record of this grievance will be comprised of 1, the recording of what is presented here tonight, and any transcript made of that recording. 2, the correspondence and documents relating to this grievance, which have been supplied to the board by the superintendent at the Level 2 record. And 3, any additional documents considered by the board at this proceeding. And 4, the Judson Independent School District's board policies concerning public complaints at GF Legal and GF Local. And 5, the agenda of this meeting. And 6, the minutes of this meeting once approved. For the record, Mr. Garza is present at this Level 3 grievance. Mr. Garza, will you please identify yourself for the record?
My name is Christopher Garza, and I wanted to defer. Oh, okay. Is that how?
Just the present.
Got it.
Yeah.
I'll present.
Thank you. Thank you. And will members of the administration please identify themselves for the record?
Dr. Rob Fields, Superintendent at Judson ISD.
Good evening. Is this working?
Yes.
Good evening, Board. My name is Hannah Kramer. I'm an attorney with Walsh Gallegos, and I'm representing the administration tonight.
Dr. Lacey Gosh, Assistant Superintendent.
Thank you. I will now instruct the parties regarding the procedures to be followed in this hearing. The hearing will be conducted in accordance to the district's policy governing public complaints located in GF Local. The order of this proceeding will be as follows. There will be no opening statements other than what the parties present in their statements in making this record. First, Mr. Garza will present his level 3 grievance to the board. This is Mr. Garza's opportunity to fully present his grievance for the purpose of this record. In the interest of fairness, when Mr. Garza has completed his level 3 appeal presentation, I will similarly allow administration to give the administration's response. As the presiding officer of this hearing, pursuant to Board Policy GF Local, I am imposing reasonable time limits on the grievance presentation by Mr. Garza and the response by the administration. Mr. Garza will be allotted 15 minutes to make his presentation. The administration will then have 15 minutes to respond. At the conclusion of both parties, I will allow each party 3 minutes to give a rebuttal statement. At the end of that time, board members may ask questions of either party. This is a grievance presentation and not a formal evidentiary hearing. There will be no questioning or cross-examination of witnesses by the parties to this grievance. Within the specified timelines, Mr. Garza will make his presentation, which may include statements and references to documents previously submitted by Mr. Garza and by the administration. The administration then will be given an opportunity to respond in kind. The board will not consider documentation not previously submitted by Mr. Garza unless Mr. Garza did not know the documents existed, nor will the board consider any complaints that were not timely submitted in accordance to the applicable grievance policy. Board members may ask questions of the parties as will aid their understanding of the grievance and administrative response, but the parties will not ask questions directly to one another. If any board members have questions, however, I request that they refrain from interrupting or asking such questions until I call for questions so that we can maintain an accurate record of the time used by each party. Are there any questions regarding the procedure of this hearing?
I have questions.
Okay, yes, Mr.
Okay,
Garza.
so the first question that I have is based on the idea that that you guys made decisions on your own to make determinations that you could be impartial to my case. However, I will say that actually some of you are listed in the documentation of which I gave to you guys. So I mean, it's a little hard for me to believe that there will be impartiality when it comes to that, because some of my complaint actually has to do with certain members of the school board.
Well, and when I asked the question if they could make a decision and be impartial, all we can ask is if they say yes, then legally they're permitted to participate. Is that correct?
Yes.
And so they would be able to legally participate.
It doesn't seem right or fair in the fact that 3 weeks ago or whatever, there was a posting about me being a convicted SO, and this person said facts are facts, like basically posted. So, I mean, I don't know how that can be determined that anybody can actually pertain or stay impartial when there's already that kind of evidence, not to mention half this book. So I really don't feel comfortable in the idea that I know that I already have at least one person up there that's already going to be, that's going to be opposed.
I would say that we are honored to request to have it in open session, which is not a typical practice for us, but one that is afforded to you. I would suggest that we just go through the process. You have an opportunity to grieve, and you have more than one board member here.
I understand, but also from other stuff that I was able to find, because unfortunately I haven't been able to get any open records requests from you guys. So from other stuff that I was able to find, it actually lists other board members up there. So I actually have an issue with 2 board members up there saying that they can stay impartial, because this basically ordinance that you guys wrote was very tailored, and it seems as though these 2 people happened to be the ones doing the surgery to tailor it.
Mr. Garza can raise these arguments.
Yes.
Mr. Garza, you can raise these arguments as part of your 15-minute presentation. Right now is the time for you to ask any questions.
Well, I'm asking,
that you
can we
have.
please remove these people from the, from this discussion? That's what I'm asking.
And we've asked, and if they say they can be impartial, we have to allow them to stay. So that's on the record, and it's been asked.
So just because it's been asked, again, they're listed here, and in that alone should have already negated the opportunity for those people to actually be part of this discussion. That's all I'm saying. I mean, this, you want to talk in fairness, I mean, it's like, well, we asked, but realistically, like you guys obviously know, there's a major issue with at least one of you. And the fact of the matter is that person should recuse themselves from this whole discussion.
Mr. Macias, if I may respond, the board will have an opportunity to deliberate all of the issues that you bring to their attention in closed meeting, including this one. This is a public meeting because you've requested this hearing be in
wanted it to be a public meeting,
and
yes.
so every person on this board and every person in the public is entitled to hear what you have to say and hear what the administration has to say. But the board will have an opportunity to consider your concern and your request before they make their decision.
I don't see how that's possible in the idea that, again, these people said they could be impartial when it's obvious they can't. So
Well,
I'm asking that that person recuse themselves from this discussion.
And that's noted.
That's what?
That's noted. Your request
Noted.
is
Okay,
noted.
perfect. As long as it's noted.
Well-
Do I have to call out which member I would like to make that request towards? Just so it's noted?
I was going to say it's okay to do that.
Okay, I would like to say that the issue that ran through, obviously, through the amount of stuff that I have
And
here.
Mr. Garza, what I'm going to do is I'm going to start the
Well, hold on.
grievance
I
clock.
just want to note this real quick
Well-
before I start, because again, it's my request is different than what I'm asking right here.
And the reason
It's
I'm
not
saying-
the same thing.
The reason I'm saying is because it's no longer a question. You are putting something on record, so just let the grievance begin, and you can note the
Well,
beginning
no,
of the
because then you're
grievance.
going to only give me 15 minutes.
Yeah.
I'm
Yeah,
not.
no.
What I'm trying to do is make sure that this is on the record prior to starting anything else. That's what I'm trying to do.
Is it going to be lengthy?
No, not at
should
all. I'm
only
just
be-
going to list two people and tell you as to why. That's all.
Go right ahead.
It shouldn't be the reasons. It should be their names. And then during your 15 minutes, you can say the reasons.
Okay. Monica Ryan and Stephanie Faulkner.
Noted, and thank you. Now you do have your 15 minutes, and Mr. Garza, you may proceed with your level grievance
Okay.
presentation.
So first off, I want to start off by stating that I received this from my level 2 grievance, and it was basically this documentation here that stated why I was being taken away from all JSD properties. And from that or whatever, it states on here very distinctly that it's court use only, and it has very distinct identifying information. So at that point, I started to ask the question, now where did you get this? And that seems to me as though it's an illegal document. The only way that anybody can get a court use only document is to be a lawyer, to be a DA, to be a cop. I mean, there'd have to be a very distinct reason to get court use only documentation. Now, don't get me wrong, I thought to myself, maybe Colorado has a little bit of a different edge on this or whatever. So I looked up Colorado's open record request laws. And basically it came here from colorado.gov that personally identifiable information such as place, date of birth, home address, social security number, physical descriptions are all basically things that would have been redacted. Now, if you look at these things, I'm pretty sure this is now going to be a public record if somebody requests my name. And if you look at these things, all of these are listed, which means that somebody got this and did not go through the proper channels. So first off, the first thing I'm fighting is the idea that that was the scenario. So going from there, another thing I will point out as we're going through the level 3 is the reason why I asked for these few things was because I wanted to make determinations as to, why, I was, these are the remedies that I wanted. So the first one was to repeal the criminal trespass warning, restore access to all JSD properties. Now, the reason why I'm asking for that is because I am a councilman. I was currently running again this term. I did not win, but by 8 votes. But I will tell you that even putting this grievance or this thing on me actually caught the attention of one of my opponents, who basically wrote, Mr. Garza is banned from all Judson ISD properties, and it says, I urge you to vote, but please think about the type of person you're making decisions affecting the city. So even just placing this type of thing on me immediately gave people the impression that I did some horrible SO thing to a child, which never happened, first off. So I'm having an issue with that piece right there. And the thing is I want to have access to all JSD properties because I pay taxes. When I read through your Judson ISD secondary thing here, it basically stated that I wouldn't have access because, what does it say, remedy? They denied it because of your policies. Your policies of which were written due to one lady who wrote on social media here, and this is where it comes into Monica Ryan. Thank you, Miss Monica Ryan, for listening to us. We need to protect our children. Now, this lady actually ran for city council this last run, number 1. This is Jessica Sanchez. Okay, she ran for city council, but another thing that she ran down was this whole idea that she was passing out these forms at Hopkins Elementary, of which, from my understanding, wasn't allowed. And she came here to change this this ordinance that you guys have, or this policy. And what happened was it was very tailored. So when I read through the policy is very distinct. Number 1, it doesn't focus on anything with Texas law because Texas law is very distinct as to what qualifies you as a SO, okay? And what happens is now we took it so far out of jurisdiction that now we can do it for any place we find it. Now, when I talked to Ms. Gosh and I talked to Dr. Fields, basically I was told that there was absolutely no way that I could, that they would check into that from, you know, everybody else, right, to all misdemeanors. Because the thing was if it was brought to their attention, then it would automatically be a situation of which they had to deal with. But until then, that it could be just fine, which obviously gives this good opportunity to just target individuals, especially politicians in small markets like me and Kirby. And the problem that I was having, again, with Ms. Faulkner at the time was basically that she has been a very big opposition to people like me, people like Roger Romans, people like Jack Miller, people, you know, who may show up and cause, you know, issue because they're activists because they believe in the First Amendment rights. Now, the thing is again, it kind of plays out on this line where it's like, well, they support, you know, our, what's it called, our city, right? Because they take mayors out to things like this, and you know they basically will support anybody they want to get into office. And see, this is where getting everybody out of city politics came in. Now I got told no on that one because it was basically that it's denied because Judson ISD as a public institution interacts regularly with both formally and informally with cities. Now you do, but the problem is you're not to get involved in our elections, really. I mean, seriously, I can't imagine why the school board would have any right or reason to do that. But it seems as though that's exactly where this is headed. And it doesn't seem like it's fair or right to be doing that, because now you guys are picking and choosing and writing policy to make determinations as to how people can get elected. Because again, as it's written here from Mr. Mike Grant, who actually won this election, these are the people you have to watch out for, me, because I obviously am banned from all JSD properties, which gives a really bad look on me regardless of what actually went down. Okay? Now, if you look towards the policies that were written, and from my understanding, again, I haven't been able to get any open records because the open records requests have been over hundreds and hundreds of dollars. You're talking minimum $500. And I tried to get open records towards Stephanie, and I tried to get open records towards Monica, and it was the exact same amount. It's like they're going to charge 30 hours any time that I try to actually get an open records request, which equals to the sum of $500+. The first was $900, then it was $500. I mean, it's ridiculous when I'm trying to actually plead my case here, and I have no access to any of this general information. I tried to re-request to make the cost go down so that I could, you know, have it, but it never came. And that, I mean, basically, the requests that kept coming back in, even though I was removing stuff, was still at the $500 mark. So I made a complaint with the Attorney General on that end, just so you guys are aware. Also, I asked that remedy number 3 was the sanction board member Faulkner, because she's the only one that I actually had any paperwork on of the types of things that she's done to stop elections or to sway elections. And I just don't think it's right that a school board member introduces herself into that way. I mean, you know, I could imagine if I was a council member and all I kept doing from my pulpit was talk about how horrible the school board and people on the school board are, particularly this person, this person, this person. It wouldn't be right. The remedy 4 was a request to repeal district policy. I truly believe that your policy is very, like, it's like surgery. Like, you guys wrote it and it only affected me. And by doing so, again, because once I asked, like, if this would affect all misdemeanors, it was like, well, no, that was only a portion of the policy. Okay, well, how many other people will you go look for in this situation? And the answer is, well, if somebody brings it to our attention, then it's going to be a problem. But until then, it's not an issue. And that seems like a big issue to me. It seems as though I'm being targeted. And I hate to say it, for someone who is a politician and someone who goes to the schools to help. I mean, literally, this whole thing started because I was a judge at a salsa contest for Hopkins. And then the PTO at some point asked for my help to donate a bouncy house. And I went to go do that and help them raise money so that they could have field trips and end of school year activities. I mean, everything I've done for the school and for Kirby has been in the best interest of the city. And I am now being targeted, number 1, by opposition, which everybody knows that that's how it's been. If you've read any of this stuff, you can see it. But beyond that, by people that, you know, that have basically tailored a whole ordinance to me or policy. Okay, so the last thing that I have here was to basically give me my open records request, because without my open records request, like, I have no opportunity to fight my case. I mean, you guys have basically cut my legs off here because you're not giving me emails and text messages. I mean, even for the idea of what I asked for, they wanted to charge me an hour for each one of you to check your phones. And then apparently it only came up with 12 text messages. So I'm supposed to pay between that and Dr. Fields, what's that, like $150 or $140? So I can have 12 text messages? It's unfair, and it needs to be taken back. I don't think that that's right. And mainly, a lot of the questions that I have to ask here is, number 1, where did you get this documentation? Because it is illegally obtained, and it does have all my personal info. So by putting out there that I am now what's it called, an SO, and then you're putting out there that I'm banned from all JSD properties, and then you're putting my address, I mean, that really does not do justice to how this is all working out. You guys are really putting me in a situation, and it's unfair, because this is not the situation. I mean, if you want to understand the situation, come ask me, come talk to me. But it's been very well noted in the city of Kirby what happened with me. Bottom line, I mean, I ran out of money to fight this case. I could not take it to court because it ended up costing me a fortune. They needed to have some kind of a settlement put down. They spent a year on this case. And it didn't matter. You know, the funny part is when KSAT reported on this, which happened, when KSAT reported on it, the number 1 thing that they put out there, even past everything that was horrible, they stated that, you know, that when they spoke over there, that they stated that they did not have the evidence to make it felony charges or any of this type of stuff. So they went with whatever they could get. And at the end of the day, I took the advice of my attorneys and did what I felt I had to do because I was running out of funds. And because of that, now I'm being held accountable to even worse off things. You guys are holding me now to Colorado law. Like, I don't live there. I've never lived there. I've never had any issue there. I mean, the one thing that happened there, I mean, has really set apart this whole idea. And it's unfortunate that now you guys are trying to basically be a judge and jury to me all over again. It's unfair, and I don't think it's right. And again, if you look through any of this packet, you will see that I have already been bullied by one of you. And to jump on board with that bully makes you no different than the people that come in here complaining all the time. Can't do this to people, you know, and just have an expectation that it's okay. This isn't about whether you like me or not. Bless you. This isn't about whether you like me or not. I mean, seriously, if you're going to cater a single ordinance towards a single person, that in and of itself isn't right. And I'm pretty sure it might be something that's probably against one of my civil rights, actually. I mean, I haven't necessarily hired a lawyer yet, but I mean, if that's what this takes, I mean, all I told Dr. Fields and Ms. Gosh was that this type of action is just going to lead to activism and lawsuits. And that's all it will lead to.
Mr. Garza, you have 3 minutes. I'm just giving you time. You have
Okay.
3 minutes.
All I'm saying is when it comes down to this, another thing I wanted to find out in my open records request was whether or not I had the ability to see what was changed in the ordinance. Now, I can absolutely determine what it probably was in the policy that was changed. And number one, it was probably going to be something about out of state, right? Because the number one thing that this one says, from Jessica Sanchez is a big thank you to the JSD board members that approved and passed this policy. As of now, any SO who is not a parent and does not have biological kids cannot be on school grounds. Now, the idea here was because I am not a parent, I don't have any authority. But I have to say, I mean, that doesn't come into play when I pay my property taxes and my school taxes. You guys are more than happy to take my money and then sit here and tell me that I don't have any access and I don't have any fair play. I mean, I don't go on campus for anything other than when I'm asked to be there. I mean, the way that this sounds is that I've actually done something horrible. And the worst part about this is, I mean, if ever I had ever been on a campus that I wasn't like invited to, it would probably be like to walk the track during the summer or to show up to a Judson football game. I mean, understand, I am a Judson alumnus. I am somebody who right now could not show up to let's say a school function. Let's say it was what is it? When everybody from 20 years ago meets up. I couldn't show up to one of those without, if it was on school property right now, because I would be arrested. Literally, like the way that this is working out is because I am a politician, I had been invited to Hopkins and to Kirby to go watch football games, to participate in drive-through, they were having just functions. I've been invited to all these types of things, and now I'm basically hobbled because I can't show up to anything. And you know what? It hurts me as a politician, and it hurts me as a person. And the way that you guys put it out with all this stuff, I mean, it hurts me just as a human being. I don't feel that I've been treated fairly, and I feel that there's distinct opposition, of which, like I'm telling you, it's very apparent. It's like, I can be impartial. In what world, in what way? There is absolutely no way that would ever be the scenario. I mean, like I was saying, what was it? Not even 3 weeks ago, there was something posted that basically called somebody a lying piece of excrement, called me an SO, called a lady Debbie Dip something, and then another thing, and then at the end of it, it's in there. And at the end of it, 3 weeks ago, as it was reposted, this person put facts are facts.
Thank you, Mr. Garza. You've reached your 15-minute limit.
Thank you.
And now, administration, you may now proceed with your reply.
Good evening. Can you all hear me okay, or do you want me to?
We can hear you.
Okay. I'm presenting on behalf of the administration tonight, and I'm joined here by Dr. Fields and Dr. Gosh. As you've heard from Mr. Garza, his grievance contests the criminal trespass warning issued to him on February 6th, Judson ISD's relationship with local politics, a specific board member, board policy GKC local, visitor and misdemeanor policies, and a cost estimate letter that he received with regards to a Public Information Act request. Mr. Garza is a community member who does not have a student in Judson ISD, and so this complaint was filed as a public complaint. The grievance was first heard at level 2 because of the remedies that are being requested. Dr. Gosh is the Assistant Superintendent of Technology, and she served as a level 2 administrator, decision maker. I'll speak to what's happened leading up to tonight, and then I'll invite Dr. Fields and Dr. Gosh to answer any specific questions that you all might have. So first, the criminal trespass warning. The district received information from a community member indicating that Mr. Garza was required to register as a sex offender in the state of Colorado. I don't want to mention who, it was a community member who sent it, and it's not either of the people that he's asking to recuse himself, and that was submitted directly to the superintendent, who then responded. They were in about mid-January, Mr. Garza was verbally told not to come onto Judson ISD property. He didn't follow that verbal directive. He came onto Judson ISD property.
Objection. That's false.
Please
I'm
let him
sorry, that's false.
Please let him proceed. You'll have a chance to rebut, Mr. Garza.
So Mr. Garza came on to district property for the Winter Festival on January 19th. So if you turn to page 106 in your packet, you'll see the criminal trespass warning. On February 6th, Officer Ramon issued the criminal trespass warning. She's here as well and can answer any questions about that. And this criminal trespass warning is in place to protect our students and staff, and the administration is asking that that remain in place. A few notes on things that Mr. Garza mentioned. One was he mentioned that he pays taxes and should be able to access Judson ISD property. I'll just note that just because you're a paying tax member does not give you unfettered access to a district, to any school district. I also think that his status as a council person is not relevant. It's my understanding that he's no longer a council person or soon will no longer be a council person, but even if he still was, that's not relevant. This policy doesn't differentiate between what people's profession is. Mr. Garza's point about Colorado versus Texas is also not relevant. Board policy GKC is in the packet as page 31. Board policy GKC local says no adult who is required to register as a sex offender may enter or be present upon any district property. And there's a separate provision for students, parents, and guardians. So I'm talking about the section of that applies to him as a community member. This is not Colorado law. This is not us trying to apply Colorado law to Texas. This is board policy. You as board members adopted this policy, and you as Judson ISD board members are responsible for board policies. This is not Colorado law. This is just something that you all did as the Board of Trustees. The board policy refers to any adult who is required to register as a sex offender and does not differentiate between those required to register in Texas and those required to register in another state. On page 48, you'll see a conversation between Mr. Garza and a DPS employee. This says the Colorado offense 18-3-4041A, the unlawful sexual contact with no consent and the victim is 18 years of age or older, is not substantially similar to a Texas reportable conviction. That just tells us that according to this DPS employee's analysis, he does not need to register in Texas. But that does not change that he needed to register in Colorado. The other thing that I'll mention is I'm not referring to the he is upset about those documents being a part of the board packet. I'm not using those to reference. He referenced those documents, and he also mentioned that this is something that KSAT has reported on as well. So I would politely disagree that the district is the one making these documents public, since he's the one raising them. Mr. Garza is required to register in Colorado, and the district is allowed by board policy GKC to restrict an adult who is required to register as a sex offender. And for that reason, the administration denied their request to remove the criminal trespass warning. The second request is for Judson ISD to stay out of city politics. Mr. Garza mentioned about staying out of elections, but going back to the level 2 grievance, the level 2 decision and then the level 3 appeal, this is about politics, not elections specifically. And Judson ISD is a public school that interacts regularly, probably on a daily basis, if not even more frequently, formally and informally with local governments, including the city of San Antonio, the city of Kirby, Converse, Selma, Universal City, Bexar County. I mean, that's where our students live, that's where the district exists and conducts business, and we can't extricate ourselves from communicating with local government entities. And for that reason, the administration denied their request to stay out of city politics. The third request is to sanction a specific board member based on their social media posts. The social media posts are on page 55. You'll see that the most recent post is from August 2023. Mr. Garza referenced a post from a couple weeks ago, but I haven't seen that post. These are documents that Mr. Garza brought in March with his level 2 with Dr. Gosh. So anything that happened 3 weeks ago would have happened after that level 2 conference. You'll see that the most recent post that's in the packet is from August 2023. And under board policy GF, which covers this public complaint, the complaint must be filed within 15 days of the date the individual first knew or should have known of the decision or action giving rise to the complaint. Mr. Garza filed this complaint on February 8th, 2024, And so looking backwards, January 18th, 2024 is 15 district days prior. These Facebook posts were posted well before January 18th, 2024, and thus are untimely. And because they were posted untimely, we'd ask that the board deny this part of the complaint regarding the board members' social media posts. Mr. Garza also mentioned his First Amendment rights, but the board members have First Amendment rights too. And I'm not going to go into the First Amendment because I think that it's untimely, but I'll just note that the folks who post on social media also have First Amendment rights. But we'd ask that the board deny that request because those were untimely, and additionally, the administration can't sanction a board member, so that was not something that Dr. Gosh could have even done at level 2. The next 2 requests are regarding GKC, so I want to talk through that policy real quick. If you turn to page 34, GKC Local is for community relations visitors, and it lays out the policies regarding a registered sex offender on a school campus. This is not a Mr. Garza policy. This affects all sex offenders. There is a separate section for a parent who is a sex offender, and there are certain instances when a sex offender can enter district property. And board policy GKC outlines those circumstances. So for example, when a student's parent or guardian needs to enter the district property, like for an ARD committee meeting, or for dropping off their student. The policy is not overly restrictive. I mean, the policy has a carve-out for parents who need to access their students' education. And the policy goes on to say that the individual will be supervised and accompanied by school personnel and will sign in and out at the main office entrance. Mr. Garza argues that this policy is overly restrictive and prevents people from accessing the district, but in reality, the policy is intentionally crafted to allow parents and guardians access their students' education, but in a safe manner. And Mr. Garza is not a parent or guardian, and his request does not comply with that policy language. The other thing is, he mentioned that Ms. Faulkner or Ms. Ryan created this board policy. Ms. Faulkner and Ms. Ryan can't pass a policy on their own. The board is a body, it requires a majority vote. And so any statement that a specific board member did something on their own is just not how the process works. The 4th request is to repeal board policy GKC Local to remove the language related to misdemeanor offenses. This was denied because this is not within the administration's authority. The local board policy is the board's decision, and the administration does not have the authority to change board policy. Same thing with the 5th request. The 5th request is to hold all misdemeanor charges to the same standard for visitors. GKC Local is specific to visitors who it has a specific language for people who are required to register as a sex offender, regardless if the offense requiring the registration was a misdemeanor or a felony. And this request was denied because it's not within the administration's authority. Again, local board policy is the board's decision. It's not a single person's decision, it's the body's decision, and the administration does not have the authority to change board policy. The 6th request is to remove the $900 fee for a Public Information Act request. Mr. Garza submitted an open records request and has since gone back and forth with the communications department regarding the cost estimate. As of today, the cost estimate is $500. This estimate is based on the Texas Government Code's PIA cost provisions. It's not based on what's fair, like he mentioned, it's based on what the Texas Government Code says, it's the law. The district is estimating 30 hours to locate, compile, verify, and redact responsive documents at $15 an hour, and so that totals $450 for labor. And then the district is also estimating $50 for overhead charges, which covers the cost of office supplies needed to fulfill the request. The estimated charges exceed $100, and so under the Texas Government Code, the district can require a deposit before working on the request. And so the district asked for a 50% deposit, which would have been $250. He mentioned that it was 12 text messages. When the district received the open records request, the technology department pulled a report of responsive documents, and that included 1,087 email files and a phone log report with 19 phone logs. So it's not going through 12 text messages. We're talking about going through over 1,000 emails, and an email could be more than one page, but we're talking about going through 1,087 emails and looking for student information, FERPA, things we need to protect as education records, attorney-client privilege, things that are confidential or that are highly embarrassing. It's not a matter of just looking at 12 text messages. We're talking about an extensive amount of documents. This has, as he mentioned, been brought to the Attorney General's attention via an open records complaint, and the district just submitted their response to the Attorney General last Thursday on May 2nd. So now we're waiting a decision from the Attorney General on whether that cost estimate is fair. For these reasons, the administration respectfully requests that the board deny Mr. Garza's grievance and affirm the administration's response to the grievance. And thank you all.
Each side will now have an opportunity to present a 3-minute rebuttal statement. And Mr. Garza, you may go first.
Okay, so first off, when she states that I was issued a verbal warning, that was false. Just first off, that was absolutely false. I was never issued a verbal warning. As a matter of fact, after going through everything to try to find any type of records of anything, all I could find was social media posts about the whole situation. And even then, I mean, nobody called me, nobody said anything to me. Even while I was there, nobody said anything to me. So that was false. After that or whatever, I was given my my pink slip, and that was taken to my house. Okay, so that was the first time I was notified of a criminal trespass. I think it's I still think from the situation of which the lawyer states, I still think it's highly unlikely and unfair that, you know, when she's sitting here that no one board member can pass policy. I mean, I understand that, but at the same time, there is a major influence. And I've been a councilman. I am a councilman. I know that that's how that type of thing can go. When it's brought up to the attention, there can be some type of press to kind of push the idea that this needs to happen. But I will say, when she's like, this is a board policy that affects everybody, that's also a false statement. It doesn't affect everybody. I mean, I would like to know how many people, after changing this, it did affect. Because realistically, I only know of one, and that was me. So when I asked for all the criminal trespasses that had been issued and all that other stuff, I mean, those were the things that were being withheld or I was being charged over $500 for. I mean, if I get this documentation, I can better appeal to this grievance. And unfortunately, I think it's a little unfair that the lawyer has access to this type of information, but it was going to cost me $500 or $900 to have any type of information so that I could sit here and say, hold on a minute, this is what was stated, this is how this was said. It is unfair. When it comes down to it, there's a lot of things that were stated on here as far as these requests, and I think that it's wrong that we're being pressed to follow these types of situations. I mean, even being here today, like, no one gave me any insight on how any of this was really supposed to work. I got a packet that basically didn't give me any instruction that happened of this nature. I mean, so when I walk in, I ask, and here I am automatically given all this idea. I didn't even know they were going to include this. I had to ask if this was going to be included, if they were going to bring this. I mean, it's unfortunate that there's no way for anybody to come up here and appeal to you guys with any real documentation. I mean, like she was saying, oh, this wasn't done in a timely manner. I did it as quickly as I could when I finally spoke to somebody. I mean, what was I supposed to do? Like, you know, I mean, you even said I can't submit new documentation. And the thing is if something was given, hold on, 3 weeks ago, I should be able to submit it so you guys can see what's going on here.
Thank you, Mr. Garza. Administration, you have 3 minutes to rebut.
Thank you, sir. So I want to make a few notes. One is I would respectfully disagree that he did not receive the verbal warning. It's my understanding that he was issued a verbal warning in mid-January. I'd also respectfully disagree that the board policy only affects him. I mean, this board policy is in place for a very large school district and affects every person who's a community member of that school district. I also want to clarify that the district is not withholding the documents. The district is following the Public Information Act that's in the Texas Government Code, and the cost estimate letter is based off the Texas Government Code. I'd also say that the Attorney General has a nice calculator online, so you know the districts can check their math. I mean, this is not something that the district just made up. This is based on the law that's laid out in the Government Code. I want to also let you know that I don't have, you mentioned that it's not fair because the lawyer has the documents. I don't have the 1,087 documents. And I'm also sympathetic about not having insight on how this works. I recognize that this board, board policies are not something that people deal with every day, and it can be overwhelming or hard to understand. And my response to that is that as a councilman, he knows how these things work and he can ask questions. And he's welcome to ask questions. And I think that I can speak for the administration by saying that if he would have asked, somebody would have explained, okay, look at board policy GF. And if you look at board policy GF, it's page 9 in the packet, and I'm looking at page 5 of 6. It says that the superintendent shall provide the board the record of the level 2 appeal, and the individual may request a copy of the level 2 record. And then it goes into what the level 2 record includes. Now, Mr. Garza has a right to request a copy of a level 2 record. The administration proactively provided him a copy of the record. So I'm not unsympathetic to how overwhelming this process can be, but I do believe that the administration took as much effort as they could to make this an accessible opportunity. So thank you.
Thank you. The Level 3 Grievance Conference is now concluded. Before we excuse the parties, I will now review with the members of this board the proper process for reaching a decision in this case. Having heard the Level 3 grievance, the board has several options. One, the board may vote to grant the Level 3 grievance. 2, the board may vote to deny the Level 3 grievance. 3, the board may vote to grant in part and/or deny in part any part or all of the Level 3 grievance or requested remedies. And number 4, the board may take no action. In making its decision, the board should consider only the grievance presentation and administrative response presented tonight at this meeting, as well as the documents contained in the record. We will not consider any statement, rumor, or other information that we may have heard outside of this meeting. At this time, I'm going to ask the board members and Mrs. Kyle to step into closed session pursuant to section 551071 of the Texas Government Code. So, yes. Yes, I did mention, did I? You know what? I did. You're absolutely right. I did skip that. So I read really important information, so we're going to pause and not go into closed session yet, but appreciate that, Ms. Stanford. Are there any questions from the board? And I see, Ms. Stanford, you have a question. So go right ahead, Ms. Stanford.
Well, I don't really have a question so much as what I want to say to Mr. Garza directly, and that's that I'm hearing your frustration, and it's very difficult to know all the information given in a situation that has occurred going back so many years. Sure. I'm an at-large rep, so I have the responsibility to represent everyone in the district, and that includes some parents who may be politically motivated, I don't know, but it includes parents who have kids that go to Hopkins and Kirby that are uncomfortable. Now, there's no way I can prove if their motive is genuine or if it's, but it's there and expressed, and I can't ignore that. So I hear you, and I feel your frustration, and I don't know how to make it truly fair. I will say that no one can judge you but God, really. No one has the wisdom or the authority to do that. All we can do is try to be as fair as we can with as many people that we're serving as we can. And that's just what I wanted you to know personally. And I'm sorry for your frustration too.
Ms. Ryan?
Oh, I'm sorry. I just had one question. You are referencing a piece of paper in front of you, reference me. Does anybody know what page number that's in the book? Because I couldn't find that. I flipped through twice.
Yes.
No, the thing with my name on it from Facebook.
No, it's
Oh, it's not in there?
It's
Okay.
not in
Nope,
there.
that was my only question. Thank you. I just want to make sure I didn't miss it.
Okay. So now we'll continue. We're going to go into closed session with Ms. Paige Kyle. pursuant to section 551071 of the Texas Government Code, so that we may ask Ms. Kyle any questions that we may have about any legal issues involving this grievance. The time is now 7:04, and we will go into closed session. board will now reconvene in open session. The time is now 7:26. No final action, decision or vote was taken while the board was in closed session. So now that we're back on record, we're here to hear the agenda item and consider action regarding level 3 grievance filed by Mr. Christopher Garza. Do I have a motion regarding this grievance?
I move that we deny the grievance of Christopher Garza and also deny the requested remedies.
Second?
Is there any discussion?
I would, as Mr. Garza requested, I am going to recuse myself from this vote.
Russ? Okay. So for the record, Ms. Faulkner is recusing herself from this vote. So we have a motion, and who made the second? Ms. Rodriguez made the second. So let's go ahead and proceed to vote. Ms. Stanford? Are you going to cast your vote? The motion passes with one abstention for Ms. Stanford. And there being no further action, this meeting is now adjourned at 7:28.